I think it'd be an unusual client, so challenging but fun.
For example, Wayne Enterprises in the Batman films. They've registered that.
Well, I know Marvel have actually got a lot of protection.
This is really weird, okay?
Yeah, that's why it's good to go to a trademark attorney. My name's Amelia Skelding. I'm an IP director and chartered trademark attorney at Swindle & Pearson.
So I'm Alexander Pickles. I'm a chartered trademark attorney and partner at Meisner Bolter. I head up the UK trademark practice. It's got to be the Marvel superhero franchise. I find it really interesting how it's transitioned from being effectively a set of comic book characters and has gradually branched into the Marvel Cinematic Universe. And we're seeing characters from the traditional comic book medium, such as Spider-Man or Iron Man. And then, of course, you'll often have the titles of the films.
Yeah, like with Avengers, there's Avengers Endgame, Avengers Infinity War. There's a couple of different ones. You've got the main brand and then all the sub-brands.
Sub-brands, yeah.
And then also Harry Potter's one of my favourite ones, and one of the IP aspects that captured my attention is the theme tune or like soundtrack, where it's got lots of different characters, interesting storylines, multiple books, so all the different titles, and the books and films, and then also merchandise coming from it.
Superhero franchises and fantasy franchises will generate characters that you could actually trademark the names of. It's more difficult, for example, in a situation where it isn't a fantasy setting, because the names are not as original.
Like Iron Man, Spider-Man, they're all really distinctive names which are registrable, whereas if it's more real life, then a lot of the characters' names are, like you say, from like John Smith, or a lot more normal name that isn't really protectable.
It's definitely something that can act as a badge of trade origin, which is one of the main goals of the trademark system.
But yeah, the more unique, the better, so fantasy is always a good one for that. If it's the first one, then it'd be a bit more starting from scratch, I think, looking at what elements need to be protected, so the title, the character names. But I think if it's one of the later versions of the film, then I think they may take more of an overview at what existing protection they have, which protection they need for the new films moving forward, and where there are any gaps in protection to make sure they've kind of got all aspects of their IP protected.
It often depends on when the producer comes into the process. So if it's a relatively new character, they've got to start from scratch. But if it's a more established character, they'll be looking at what already exists in terms of protection. So you may have protection, for example, Class 16 comic books in the Marvel example. And then when you're extending to films, you'll be looking at other classes of goods and services, and then you need to think about merchandising thereafter. First and foremost, trademarks. We are trademark attorneys. That would be protecting, the name of characters, the name of the film. And then you would also have copyright, which exists as a right, so you don't have to register copyright in the UK, but it would cover the scripts, it would also cover the film sequences themselves, any musical scores attached.
Yeah, then there's also designs, so that would protect the design of the costumes, for example, like Spider-Man costume. And then there's also potentially set design, maybe, if it's in a particularly unique way. And more tangential, but potentially patents would also be relevant. Some kind of special equipment for stunts or something like that. There might be some patentable subject matter in there. Marvel have actually got a lot of protection for the figurative images of particularly the comic book side of things.
Oh, yeah.
They've got protection for the kind of sketches of the superheroes and things, but...
Most superheroes, they will have the name of the superhero, so Batman, and then you will have the sort of Batman crest, which is the emblem of a bat across his chest. I've seen that DC has various versions of it because the Batman logo consistently changes throughout the films. I've also seen, and this is really weird, okay, quite often you'll have businesses within the within the franchise's concept. For example, Wayne Enterprises in the Batman films. They've registered that. And then, I don't know about Stark Industries, but another one is if you think about the Alien film franchise, Weyland-Yutani is a registered trademark for putting on clothing. I've often seen it's how they place them around films as well. So if you think about TV advertising, they're trying to work out what is the best part of the film. So for example, if you've got the sort of centerpiece and the action sequence of a film, the advertising slots around it will be far more expensive than just say at the beginning, or, you know, at a less interesting point to be watching the telly.
Yeah, if they've got a car scene, getting your car brand, you know, in that car chase or whatever would definitely be a very desirable spot in the film to feature a product placement.
I once saw one, so you watch the Marvel ones, you have Audi driving around, and then like they stop the film right in the middle of the car chase, and it's an Audi advert. So, you know, seeking legal advice in terms of freedom to operate is really important at an early stage. You could invest a lot of time and effort developing artwork, concepts, you know, potentially even most of a film, only to find out that your desired trademarks that you want to sell the end product under are no longer available and that you're blocked. So
that's why it's good to go to a trademark attorney, because they can make sure you're future-proofing yourself as well for later merchandising and licensing later down the line, because you obviously need very different classes for those kind of products versus generally like the film itself.
You put 3 or 4 years into, you know, creating the concept and then filming a film, and then just getting, let's say, the title wrong, you might have to pull it from the cinemas, and you can get injunctions to the court that will do that, and then you'd have to rebrand, or in the worst case scenario, maybe stopped altogether.
Yeah, there's so much time and money that's spent in the film production industry. You want to make sure that your brand is solid. Consider IP an asset from the start and not an afterthought. Often production companies are very focused on the creative process, but they forget to take into account the real value of their IP. So if they do have a good strategy in place, rather than being a project-based company, they can become an asset-based company with long-term investment.
My top piece of advice would be plan for the future. Quite often a brand will develop in ways that you may not expect, and therefore it's a good idea to be thinking, you know, where could this be in 5 years, and also to conduct routine checks to make sure that your protection is up to date.
It would be Willy Wonka, because I love chocolate and got lots of distinctive brands, so like the Wonka bar and the exploding gobstoppers and the 3-course meal chewing gum, so potentially some inventions in there too, so maybe patents could be helpful. I think he'd be an unusual client, so challenging but fun.
It's got to be John Hammond and InGen from the Jurassic Park franchise. It would be absolutely brilliant to file the trademark for Jurassic Park covering Class 31, live dinosaurs, and Class 41, theme parks.